The politics of the Netherlands take place within the framework of a parliamentary representative democracy, a constitutional monarchy, and a decentralized unitary state. The Netherlands is described as a consociational state. Dutch politics and governance are characterized by a common striving for broad consensus on important issues within both of the political community and society as a whole. The Dutch constitution lists the basic civil and social rights of the Dutch citizens, and it describes the position and function of the institutions that have executive, legislative and judiciary power. The constitution applies to the Netherlands, one of the 4 constituent countries of the Kingdom of the Netherlands. The kingdom as a whole has its own statute, describing its federate political system. The Netherlands comprises all of the European territory and also the Caribbean islands of Bonaire, St. Eustatius and Saba. The Netherlands does not have a constitutional court, and judges do not have the authority to review laws on their constitutionality. International treaties in the Statute of the Kingdom, however, overrule Dutch law and the Constitution, and judges are allowed to review laws against these in a particular court case. Furthermore, all legislation that is not a law in the strict sense of the word can be tested on their constitutionality. Amendments to the Constitution must be approved by both houses of the States General twice. The first time around, this requires a majority vote. After Parliament has been dissolved and general elections are held, both houses must approve the proposed amendments with a 2/3 vote. Major political institutions are the monarchy, the cabinet, the States General and the judicial system. There are 3 other high colleges of state, which stand on equal foot with Parliament but have a less political role, of which the Council of State is the most important. Other levels of government are the municipalities, the water boards and the provinces. Although not mentioned in the Constitution, political parties and the social partners organized in the Social Economic Council are important political institutions as well. It is important to realize that the Netherlands does not have a traditional separation of powers. According to the Constitution, the States General and the government share the legislative power. All legislation has to pass through the Council of State for advice, and the Social Economic Council advises the government on most social economic legislation. The executive power is reserved for government. Note, however, that the Social Economic Council has the special right to make and enforce legislation on several sectors, mostly in agriculture. The judicial power is divided into 2 separate systems of courts. For civil and criminal law, the independent Supreme Court is the highest court. For administrative law, the Raad van State is the highest court, which is ex officio chaired by the king. The Netherlands has been a monarchy since the 16th of March 1815, but has been governed by members of the House of Orange-Nassau since 1556. When William of Orange-Nassau was appointed stadtholder and led the successful Dutch revolt against Spain, the present monarchy was founded in 1813. After the expulsion of the French, the Prince of Orange was proclaimed sovereign prince of the Netherlands. The new monarchy was confirmed in 1815 at the Congress of Vienna as part of the rearrangement of Europe after the fall of Napoleon Bonaparte. The House of Orange-Nassau were given the present-day Netherlands and Belgium to govern as the United Kingdom of the Netherlands. Between 1815 and 1890, the King of the Netherlands was also Grand Duke of Luxembourg. The current monarch is Willem Alexander. The heir apparent is the Princess of Orange, Catharina Amalia. Constitutionally, the monarch is head of state and has a role in the legislative process. He has to co-sign every law to make it valid. The monarch is also ex officio chair of the Council of State, which advises the cabinet on every piece of legislation and is the final court for administrative law. Although the current king takes these functions seriously, he refrains from exerting his power in these positions. The monarch also plays a central role in the formation of a cabinet after general elections or a cabinet crisis. Since coalition cabinets of 2 or more parties are the rule, this process has influence on government policy for years to come. The monarch used to appoint the informator until 2012, who chairs the formation talks, after consulting the fractievoorzitters of all parties represented in the lower house of the states. General. When the formation talks have been concluded, the king appoints the cabinet. Because this advice is a matter of public record, the king cannot easily take a direction which is contrary to the advice of a majority in parliament. On the other hand, what is actually talked about behind the closed doors